And joining us on the line right now is Joe DiGenova, our legal analyst, former U.S. Attorney to the District of Columbia. Joe, good morning to you. Good to have you here this morning.
Good morning. Good to be with you
All
guys.
right, so this is Monday. There are 2 Mondays left in the month. We have 11 big decisions that are still expected to come down. We should see some of them perhaps today from the Supreme Court. The 2 big ones, I guess, are gay marriage and also whether or not the Affordable Care Act, Obamacare, is actually going to withstand constitutional scrutiny. And what has been interesting about this, Joe, to me, is that the president has been out there already talking about this issue and really sort of, dissing the Supreme Court. I can't recall a sitting president ever doing this before.
Well, the last one to do it with any regularity was Franklin Roosevelt. This president, who considers himself a constitutional scholar, which he is not, his ignorance of the Constitution and Supreme Court president is actually quite remarkable when you listen to the things he says. He doesn't even having a passing acquaintance with constitutional principles. But that aside, the president believes, because this is the way he governs by meanness and by demeaning people. He thinks you can affect judicial behavior, and he's right, by the way, of the Supreme Court because he thinks it's fundamentally a political body and that he can influence them by shaming them into decision-making. This is the second time he's taken this position on Obamacare. The first time was when he attacked the court after Citizens United and actually conducted a campaign against John Roberts so that he would not find Obamacare unconstitutional, and it worked. And he thinks that he can affect Kennedy and Roberts again by essentially criticizing them publicly for being so stupid as to have granted cert in cases that were of major importance. Can you imagine any other president having the temerity to act like the Supreme Court should not have taken a case? The conduct of this lawyer, and I use the word advisedly, the conduct of this lawyer, Obama, is disgraceful.
Well, let me ask you a question. Do you think that it's possible that this president has gotten a polite back-channel heads up?
No.
You don't?
No, absolutely not. For all of his innate arrogance, the president wouldn't risk that sort of thing, and none of the justices ever communicates with the executive branch, whether they're liberal, moderate, conservative. Believe me, there is no communication outside of that court. It is probably the best-run institution in Washington, D.C. in terms of keeping a secret. But no, he hasn't gotten anything, and that's exactly why he's doing what he's doing. I mean, he really believes that he can affect the behavior of at least one, perhaps 2 of the justices on the subsidies case involving Obamacare. And he has reason to believe that he's right in light of what Roberts did in the last case.
Can I ask you, Joe, if, and we may get this decision, within hours.
10 o'clock.
If the Supreme Court decides to strike down the federal subsidies for those states that have not set up an Obamacare exchange, what then would the timing be for people? I mean, there are people in Virginia right now, through no fault of their own, who lost their privately held insurance because of Obamacare. They were forced into these exchanges because of their income. It costs a lot more to buy Obamacare insurance because of all the coverage that they didn't want that's forced on them now. So they are getting a subsidy right now. What happens to those people? What's the timeline? Do they lose their money immediately?
Well, that will depend on what the Supreme Court does, assuming, and this is a big assumption, because I don't think they're going to strike down the law. I think they're going to do exactly what they did the last time. They're going to punt. They're going to cave to political pressure.
Really?
And believe me, the court will rue this day. Yeah, I don't.
Wait, hold on, because
I don't have any confidence in Roberts or Kennedy at this point.
Well, what? I got to ask you this before you answer my first question. What basis of U.S. jurisprudence would they be using? What case law would they use? They would be using
the first Obamacare case, in which Chief Justice Roberts, out of whole cloth, rewrote a federal statute. Remember, the first Obamacare case was not a constitutional decision. It was a statutory interpretation. He saved the statute by saying it was a tax, even though the president and Congress and everybody else said it wasn't. If he can do that, if he can manufacture a tax out of nothing, a tax which did not originate in the House of Representatives like it must under the Constitution, then he can do anything. And they can reinterpret the statute and say, oh, this was an accident. If it's clear what they intended, blah, blah, blah.
It was really more egregious than that because in the House of Representatives, they made the case it was not a tax.
Of course. And so if they can do that, if Roberts can actually get up in the morning and look at himself in the mirror and smile and do that, do you think he can't say that Congress actually intended the subsidies to extend to the federal exchanges, even though the literal language of the statute says that it doesn't?
Yeah.
Of course they can do it.
All right, so now back to my first question.
Happy days are here again.
Yeah, really. I mean, like, thanks a lot, Joe. So if they did, if you're wrong, which is, God forbid, what then happens to people who have insurance right now?
If the Supreme Court says it's fine, well, if they strike it down, the Supreme Court will probably say this mandate will take effect in 90 days. In other words, when the court issues an order, it issues something called a mandate. And the mandate is the order from which all courts and all government agencies must operate. They may say this order will take effect in 90 days in order to give the Congress and the President time to work out a compromise. If nothing's worked out after 90 days, people lose their coverage. And they should, because Obamacare is a legislative fraud.
So one of the couple of things about South Carolina I've been wanting to ask you about, we had a conversation a moment ago that it seems that this administration doesn't want to call what happened there an act of terrorism. Yet when I look at the definition of terrorism, it seems to fit. What's your thought about that?
Well, there's no doubt it's an act of domestic terrorism. I was listening to the FBI director, Mr. Comey, Cardinal Comey, as we call him here in the Outland. They obviously do not want to call anything terrorism anymore. This started with the nonsense about not calling Fort Hood an act of terrorism. And this goes back over the whole term of this administration. They have a narrative. Their lying has worked. He got 2 terms. There is no terrorism anymore. All these things you see are not really happening. You have bad eyesight. That's what this is about. This is politicizing a horrible act. This is clearly domestic terrorism. The guy was a racist. He had a racist philosophy. And he wanted to influence a large group of people, both black and white, politically. It is the classic definition of terrorism. And to hear the administration say that it isn't is just another example of the way they are into, George Orwellian logic.
They want to apparently call it a hate crime. Can it not be both?
Of course it can be both.
Of course it can, right.
Of course it can be both. I mean, see, one of the things the administration wants you to stop doing is thinking clearly. So that's why they use all of this sophomoric description of things. And you say to yourself, are they really saying that? They can't be that stupid. Well, they're not stupid. They're conniving.
Yeah. Joe, real fast, we only have 30 seconds, but sticking with the Supreme Court theme here, if in fact they do strike down same-sex marriage, which I say most court observers think they will maintain same-sex marriage, but if they do strike it down, then what happens to people who are married right now?
Well, if here's what they should do. They should rule that each of the states has a right to define marriage any way they want to, which they have been able to do since the beginning of the Republic. If they do that, they can say, however, under the full faith and credit clause, any state that does allow same-sex marriage must have that marriage recognized by any other state under the Constitution. That's the way they should resolve this. Regrettably, I don't think that's what they're going to do.
What do you think they're going to do?
I think they're going to say there's a constitutional right to same-sex marriage under the Equal Protection Clause, which, by the way, same-sex marriage is fine with me, but there ain't no constitutional right to it.
Joe DiGenova, great to have your pre-SCOTUS decision analysis. Right. We'll look forward to your post-decision analysis.
Thank you so much.
All right, thank you, Joe.